Hi, this is David Demerjen for Legal Update for Tactics and Trials. I appreciate everybody's comments regarding Legal Update 1. Let me address some of those comments. As for some of you who said that I need to comb my hair, I want you to know my hairpiece is en route, and hopefully that will make you happy the next time I do another update. Others said that it looked like that I wasn't a member of a bar, but I was sitting in a bar. Well, the unfortunate or fortunate part is I am a member of 3 state bars. As I told you earlier, I've been practicing law for 30 years, representing mostly police agencies, police officers, law enforcement officials throughout the country, mostly in use of force, but in a whole range of topics, most recently here in California. I have sort of a unique understanding or keen insight into this area, but most importantly, I'd like to be able to look at some of the opinions that are coming out nowadays and decipher them. It is very confusing, and there are a lot of terms here and a lot of strategies and a lot of protocol that people need to be aware of, and hopefully my updates will be able to give you some insight into it. Now, please remember from the warning in the beginning, I'm not your attorney. There is no attorney-client. I'm doing this for information purposes only. If you have any questions, please seek competent counsel for the jurisdiction that you're in. I most likely am not in your jurisdiction, and if I am, please seek counsel that you're used to working with or someone you'd like to be able to ask to give you the appropriate response to any of your questions. As always, we're going to be covering a case from the Ninth Circuit, and as I told you in our last update, the Ninth Circuit is the largest court of appeals in the federal circuit system. It covers most of the Western Conference. It generates a lot of opinions and quite a few use of force cases. This is a use of force case that we're going to be reviewing. On that note, all use of force cases are a tragedy for all parties. And it's nothing to take light of. It's unfortunate that it does happen within the scope of law enforcement. And it would be nice to think that in the end, we have a harmonious and happy result in every encounter in law enforcement. Unfortunately, the reality of the job, it doesn't always happen. And the matter that we're going to discuss is Smith versus Agdepa. It was published December 30th, 2022. It is a divided panel, a 2-1 panel, that affirmed the denial of the officer's summary judgment based on qualified immunity. And we'll cover all these topics again when I get into right before the fact pattern. The case came to the Court of Appeals by way of an interlocutory appeal from the denial of qualified immunity at the summary judgment stage of the litigation down below in federal district court. Now, let's go over some points. What is qualified immunity? What is a motion for summary judgment? Let's start with the motion of summary judgment. Motion of summary judgment is the little pretrial litigation tactic used by one party in order to avoid going through the entire trial proceeding. This is done in pretrial, usually around discovery. You'll have your depositions, requests for admissions, requests for production of documents, a whole slew of different discovery strategies go on at this stage, and information comes in. At one point, one of the parties is going to take that information and put a motion in front of the court and say, hey, listen, based on the facts we now know, and based on the law at the time that this encounter occurred, there is no case here. And we're asking the court to take away the plaintiff's right to go to trial, which is a very high standard in order to keep that happy and be able to comply with all the constitutional parameters of motion for summary judgment. So the Ninth Circuit doesn't easily grant it, particularly in wrongful death actions. So in this case, again, a motion for summary judgment was denied down in lower court, federal district court, and is taken to the Ninth Circuit Court of Appeals. Now, what was denied? Qualified immunity to the office. What's qualified immunity? As the Ninth says, the Ninth determines whether the facts viewed in the light most favorable to the plaintiff, in this case, the party that unfortunately passed, showed that the officer's conduct violated a constitutional right. The court then asked that that particular constitutional right was clearly established at the time of the incident. If the right was violated and it was clearly established, no qualified immunity for the officer. So basically, first of all, was there a constitutional right violated? In this case, a Fourth Amendment right. Mr. Dorsey was seized with the most ultimate form of seizure, which is death. And was, on this fact pattern, was the officer aware of what he can and can't do in this incident, or before he got involved in the incident? And that's what the court is saying here. You don't get a qualified immunity, officer, if there was no constitutional right violation, or if there was a violation but the right wasn't clearly defined. Then the officer's motion for qualified immunity is granted. Motion for summary judgment, no need to go forward. You're out of the trial, and that's it. But the court denied the summary qualified immunity for the officer, denying the motion for summary judgment, and that was what's up in appeal. The Court of Appeals reviewed what they did down in district court and affirmed what the lower court did. As the court ruled, deadly force is reasonable only if the officer has probable cause to believe the suspect poses an immediate and significant threat of death or serious physical injury to the officer or others. Further, an officer must give warning before deadly force whenever practicable. That didn't happen here, according to the court. There's a question as to whether it was practical, was it feasible? These are facts that are, or this particular fact pattern is going to have to be determined by a jury at this stage. The Ninth further held that the district court properly denied Agdepa, that was the Los Angeles City police officer, request for qualified immunity for two reasons. The district court recognized that a reasonable jury could reject the officer's account of the shooting because there were significant discrepancies between their version of events and other evidence in the record. Second, the lower court, we have long held that the Fourth Amendment regarding officers to warn before using deadly force when practicable. That's what they're saying. They did not hear stop or I'll shoot or some indication that deadly force was going to be used at that moment. And again, the court then says you're supposed to do it if practicable, if feasible, with some of the other opinions. The encounter lasted approximately 4 minutes after the officers first attempted to handcuff Mr. Dorsey. The officer tased Mr. Dorsey at least 5 times during this interval. Agdepa never limited or never claimed that he warned Dorsey that he would switch from using his taser to using his firearm. That's what the court was concerned about. The officer in this fact pattern, you'll see, does give a warning regarding the use of the taser. But according to the court, the only warning, if any, that he used before he shot was a stop, not stop or use deadly force. That was a concern of this court and the lower court plus the Court of Appeals. Now let's go to the fact pattern. On the morning of October 29, 2018, the 2 police officers from LAPD responded to the 24-hour fitness in Hollywood. At that point, they were contacted by a gym employee who says, we have an irate, agitated man in the shower or locker room area. He's not listening to us. He's already hurting a few of the members, and he's also assaulted a security guard as well. That assault on the security guard happened actually a couple of days earlier, in which the security guard was hospitalized. The officers didn't know of the severity of that attack at that time, but they did know that he had attacked some of the other patrons. The officers go into the locker area where Mr. Dorsey is and attempt to get him to comply with their lawful orders. Get your clothes on, you're out of here, you got to leave. He basically danced around naked in front of him. And by the way, just so you understand, let me give you some context here. Mr. Dorsey is 6'1", 280 pounds. The Agdepa is 5'1", and Rodriguez is 5'5". So there is a size differential between the two of them. Mr. Dorsey's response to the officers when they ask him to get dressed and to leave the locker room is basically to continue dancing. He gives them the finger and dance naked in front of them. Obviously, that's not compliance. They warn him that they're going to use a taser. They warn him that they're going to step it up. He again does not comply, keeps moving about. They go hands-on. From hands-on, tasers come out. Tasers deployed multiple times on a full deployment, also on a drive stun. It doesn't work. At one point, Mr. Dorsey actually picks up one of the tasers, and there's a lot of punching, fists being flying back and forth. Mr. Dorsey, who's of significant size, is able to handle himself with these two to the point that he pushes one officer down onto the ground. He also hits Agdepa, who, according to his testimony, is knocked against the wall and is slightly dazed by the entire impact. At this point, he sees, according to Agdepa, he sees the very large Mr. Dorsey standing over Rodriguez, his partner, and pummeling her onto the floor. In response to that, according to Agdepa, he says, stop. Mr. Dorsey doesn't, and the officer then fires multiple shots, 5, and then finally a 6, stopping Dorsey from continuing hitting the female officer who was on the ground. Now, a minute into this encounter, both officers' body-worn cameras come off. They are sitting at a different part of the locker room because this was a very powerful and very vigorous struggle. So all we hear at first, or after the first minute, is some of the audio going on between the parties. The alleged stop from Agdepa telling Mr. Dorsey to stop is not picked up by the audio on these cameras. Then again, the cameras are not right next to where the struggle is going on. So there's a question as to whether or not that did occur, which is something that the court raised. The use of the taser multiple times, there was no problem with that application of force according to the court. It was, again, the application of deadly force according to Agdepa at that point, feeling that the officer, the female officer, was in trouble. In his affidavit, Agdepa's, he stated he unholstered and drew his service weapon and gave Dorsey a verbal warning stating words in the effect that Dorsey needed to stop. Many of those words are not picked up by the audio, which the court sort of made it a disputed fact then at that point. Agdepa fired 5 shots to stop Dorsey, who began to fall backwards away from Rodriguez, that was the female officer, as Agdepa fired the final shot. So a total of 6 shots. The defendant officer's version of events are contradicted according to what the Court of Appeals says. Number one, the warning to stop cannot be heard on the body cam audio. That was a big concern of the Ninth Circuit. Number two, the security guard's accounts recounted in an internal investigation of the shooting differ from the officer's accounts in several respects. I'm not surprised by that. After trying a number of cases, I can tell you it's very rare that instance where you have all the witnesses agreeing on the set of facts, but the court found that to be concerning. Number three, the guards that were at 24-hour fitness disagreed with the officers on the number of shots fired, whether the man reached for the defendant officer's firearms, and whether the man was holding the officer's wrist until after the second shot was fired. Number four, the internal investigation concluded that the defendant officer's use of lethal force was unreasonable because there was no exigency preventing the officers from withdrawing and redeploying with greater resources. This is part of the tactical or de-escalation tactics that they're expecting officers to do now in a situation as such. Again, at this stage of the proceedings, there's limited information or evidence as to drawing your opinion as to how those officers were supposed to go about doing that in light of the fact that this was a facility with other people walking about. Number five, further, the evidence indicated that the officer's injuries were only minor according to the panel majority. That was a concern of the court. Number six, an autopsy report also put into question the officer's statement that he shot the man from 6 to 8 feet away. Again, these are the facts that need to be fully explored in trial. As to whether or not the jury believes the officers, that will be determined in trial. Because that's what the court also said, was that whether or not the facts that the officers saying are able to be supported and proven at trial is something that the trial is needed. At this stage of the proceedings, pre-trial, in a motion for summary judgment, the court did not allow or did not give the qualified immunity to the officer to be able to not proceed, and accordingly, the trial will continue. The concern was, again, the lack of a warning before deadly force was used. There also was a concern that the threat, according to the officer, was not imminent, and that de-escalation, again, could have been used, according to the court, regarding repositioning and calling for additional resources. That's what the court raised, using this internal investigative report that they cite to in their opinion. While the suspect posed some danger to the officer's safety by actively resisting arrest, a jury could reasonably reject the officer's description of the deadly fight and find that a reasonable officer in the defendant's position would not have believed the fellow officer or anyone else was in imminent danger. That's the court's opinion, again, based upon the facts that they had or the record they have from the lower trial court or the lower federal district court. Again, this is a very difficult encounter to analyze at this stage of the proceedings. They're only going on a limited amount of information, what has been brought up through discovery, depositions, and the records or the information that was exchanged in pre-trial. They're saying basically that this entire incident has to be looked at by a jury. And then it'll be fully explored. Witnesses will be watched. Juries will believe or not believe what they say. They'll look at the autopsy report. They'll look at the video that is there and listen to the audio track in order to make a determination. Now, the interesting thing was one of the judges dissented. It was a 2-1 decision. According to the dissenting judge, he believed the undisputed facts, including the audio from the body cams and 2 independent witnesses' verification of the officer's account, indicated that the officers faced an imminent threat and that the law did not require them to issue another warning before using deadly force. Same fact pattern, same evidence, same court. Judge ruled differently. We have a 2-1 decision though. 2-1 saying matter goes back down, lawsuit continues, get ready for trial. I hope you enjoyed this legal update. Please subscribe, leave your comments. If there's something you'd like me to cover, please let me know. I've enjoyed talking with you today. I look forward to seeing you again. Be safe.